that you represent from it being in law?
Well, with all due respect, the department could do this without the bill today. And if they see the bill's been filed, the representatives brought the bill, there's no reason, there's nothing stopping them from providing a report today that accentuates this.
And they can also not do it.
They could not do it.
And therein lies the
But if the governor were to sign the bill, then that would mean he would favor that. He could very easily pick up the phone, call the Department of Labor, and they could issue the report. So why pass the bill?
Because just say the governor's not for it, or
Then he
there's
wouldn't
somebody
sign it.
here that's not for it, that
Then he wouldn't sign
believes
the
that there
bill.
should be inequity.
Then he wouldn't sign the bill.
But then hopefully, I mean, I don't know, I gotta relate, hopefully there's no opposition to this, because it just kind of makes sense.
Then the governor would just pick up the phone, call the Department of Labor.
Okay, but I think it would be better, I mean, if that was the case, we could use that with every bill that you all probably have supported.
Well, unfortunately, the governor doesn't agree with everything we want to do.
Right. So I think this is the best way of going to get it done, instead of leaving it up to, maybe somebody will, somebody may not, depending on who's running that department at that time, you know?
Well, Representative, do you think the governor would not agree with this?
I can't speak for him, I'm just represent the wonderful folks of the 85th District. Maybe he's got a representative here or something, but I can't
Maybe so.
speak for him. But thank you, sir. Thank you, Mr. Chair.
Thank you very much.
I have a question.
Very quickly, please, Representative.
So, United Industries, are you aware of any instances where women are paid less than men to do the exact same job? Not talking about education level, entry, whatever it is, same job, they make the same as the male counterparts.
It's Associated Industries in Missouri, just to be clear. And for the exact same job description, males and females, I think under today's law, have to be paid the same. I think otherwise they would have a sex discrimination case. I think the problem comes in when you start talking about equivalent work. And that's where there have been lawsuits at the federal level. I think the Lilly Ledbetter case and some others have tried to draw in equivalent pay, where you say, well, the job description is not exactly the same. They pretty much do the same thing. And that is something that still has yet to be settled in the courts. And there are a lot more details that have to be worked out on that before we can support something like that, because you get into really other parts of a person's education and exactly what a job entails. But I think for the exact same job descriptions, a person with exactly the same qualifications is supposed to be paid the same based on their qualifications and not differently based on gender.
I think that's the question, they're supposed to be paid. There was a big case against Anheuser-Busch, one of the executives sued when they sold to InBev that they hadn't been paid as one of their counterparts who was a big-time executive. The point being is, and you say, well, what if the governor wasn't for this, or the governor could pick up the phone? If it's the law, put into law, and I've seen them in the past few years try to change our Constitution, do a lot of changes in the law for something that seems not quite as important as this. So why not just have a law? And I think that's what Representative Weber's trying to do. It's the law, so you'll do it. If it wasn't a problem, they wouldn't be producing studies and saying women are making less than men, which in my opinion in this country, now maybe in China, that's okay. But here, we're supposed to all be equal. And I'd like to see the first man to stand up and say, no, you're not equal. So I mean, that's my point, and you don't have to answer that, but it's just an opinion.
Well, I guess the question is, if the studies are already out there, what is the purpose of the bill? And that's what concerns us, is what is the real purpose of the bill? If the studies are already out there that we're trying to have the Department of Labor do, then why are we asking the department to do another study if they're already out there? And if they're not, then could the governor just do this anyway?
Well, is this, Representative, is this a study, or is this going to be the law to make sure that we have equal pay in the state?
This actually establishes guidelines, best practice guidelines that businesses can choose to follow.
It's the law.
It's currently the law. My assertion is that having simply equal pay mandated by law is not the goal. The goal is to actually achieve equal pay. And so that is one tool that we use to reach that goal. This is additional tools to achieve that goal.
And if these tools are guidelines, and it's our concern, then maybe whatever the department comes up with and establishes as guidelines could be involved in a lawsuit. That's our concern. And if it's simply to get the word out on what the problem is and to bring perspective to it, the Department of Labor can do that today without a bill.
I think I'll let the representative explain that. Thank you, Mr. Chairman, for the inquiry.
Okay, Mr. Mike Lewis, AFL-CIO.
Representative Gibson, I've got a list I can send you. It truly is everybody from CEOs to secretaries, but I've got a great different industry. Yeah, thanks.
Thank you, Mr. Chairman, members of the committee. Mike Lewis, President of Missouri AFL-CIO. While it's very true that under collective bargaining agreements, all of them start out, at least on the first page, if not the first paragraph, that there's a non-discrimination clause in that contract that says everyone will be treated equally and fairly. I'm just glad to sit up here and be able to testify in favor of a bill that creates a situation to help everyone achieve some things that are a benefit of working under a collective bargaining agreement between an employer, the union, and the employees. And I'd be happy to answer any questions.
Thank you very much, sir. Are there others in opposition?
Members of the committee, Jay Adkins, General Counsel for the Missouri Chamber of Commerce and Industry. We would echo the concerns that Mr. McCarty articulated when he was up here earlier. We would also ask that if the committee is of a mind to pass this particular legislation, we would ask the committee to consider some sort of prophylactic language that could prevent these, quote, best practices from becoming dictates of the department.
Representative Lynch,
To inquire,
go ahead.
thank you, gentlemen, good to see you this afternoon.
Thank you, Representative.
Would it be reasonable to say that there is a reasonable concern that these guidelines could become mandatory requirements by the department going around the legislative process?
That is our concern, yes. We would like to see any sort of requirements of this nature ought to be vetted through this body.
Thank you, gentlemen.
Thank you.
Representative Smith,
Briefly inquire.
go ahead.
Hey, how you doing?
Very well, Mr. Representative.
One kind of question, does the organization you represent believe that there's a gender pay equity problem? Disparity?
I haven't looked at any of this research. I don't know. Our concern is that what start as best practices and suggested guidelines could very easily become an additional mandate for businesses unless there is some language to specifically prevent that from happening.
Okay. And the reason I asked that question is because it came from somewhere, and obviously the bill's sponsor was is very passionate about it, because looking at the bill number, it's 44. So out of the thousands of bills that we have now, this is one of the first out the gate. So it's an issue, but I think it's rooted in the issue, the problem that I know for a fact, whether you all want to believe it or not, that there is a gender gap, along with other gaps when it comes to pay, but this time we're talking about pay equity. So that's why I wanted to ask the question. Do you all have a position of, hey, we know it's an issue, or no, we don't know it's an issue, or?
I'm sorry, Representative. No, we do not have a position on that particular issue, and in fact, I'm not here opining on that one way or the other. My concern is that anytime we give a department, an executive agency, the ability to promulgate what could be conceived as rules, that we are putting restrictions in place on businesses without the virtue of having that vetted by this body, and that's what we're opposed to.
Thank you. Thank you, Mr. Chairman.
Representative Dorman,
To inquire.
go ahead.
Very quickly, time gets away before we realize it, but I think you kind of hinted at what I'm concerned about, that we're sort of giving away our authority. That if we believe there's a problem that legislation could solve, we should pass legislation, but yet this way we're kind of doing it, behind our backhandedly saying, well, you make up these guidelines, and would you kind of see that eventually slipping into administrative rules, something to that degree?
That's our concern, yes. I think that recommendations and guidelines, when promulgated by a government agency under the guise of being best practices, I think those things can very quickly become binding in a way that was never intended. And I think that type of rulemaking authority, should it be vested, needs to be vetted by this body and expressly either given or denied. And I just don't see that language in this bill.
Thank you very much.
Thank you, Representative.
Representative Frazier?
Mark. Mr. Atkins, we've heard that we finally got kind of an admission that maybe retailing was an area that this is a concern. I don't see one from Missouri Retailer Association here, but being Chamber of Commerce, you're pretty closely aligned with them. Do you think this bill is specifically targeted at retailing or at a particular retailer in general, or entry? You know, we talked that it was brought up that it was entry-level positions, which, you know, entry-level can still mean a lot of things. You could have assemblers, you could have stockers, you could have checkers, you could have maintenance people, and obviously the skill sets to do those different things are different. So do you think this bill is targeted specifically at that industry?
Well, and as you say that, I can see the Representative Weber shaking his head, and I've read the bill, and it doesn't, I don't know is the answer, and I only know what we've heard in testimony. It does not, I don't know if there is a, excuse me, a particular entity or industry that's being targeted here. What I do know is, as I've said before, that these types of best practices, should they be adopted and implemented, I suppose, by a government agency without having been fully vetted by this body, then I think we're putting all of our Missouri businesses in a tough spot and putting a burden in place that may or may not need to be there.
And then just a follow-up question, it's also been discussed about this won't be the law, but we already have laws on discrimination, which are very rigid and very easily identifiable. Wouldn't that protect most all of these folks?
I would think so, certainly it would, and incidentally, in the case of the representative mentioned earlier, the Anheuser-Busch case, I do think it's worth noting that Anheuser-Busch actually, at great expense, defended that case and won at trial. There, in fact, the jury found that there was no discrimination based in gender or otherwise in that case. I think that's worth noting. So, to your point, yes, we have a very robust set of employment discrimination laws that you've heard me testify in other settings, or perhaps could use a little tweaking themselves, but certainly in this case there is an avenue. If there is some sort of gender-based discrimination, employees certainly have wide latitude to bring suit.
Thank you, Mr. Chairman.
Thank you very much, sir.
Thank you.
Ms. Sarah Rossi.
Good morning, Mr. Chair, members of the committee. My name is Sarah Rossi. I'm the Director of Advocacy and Policy for the ACLU of Missouri. I was going to go into a little bit of history about the ACLU's work on gender pay equality, talk about the Paycheck Fairness Act a little bit, read a quote from an ACLU activist who helped pass the first equal pay law in the 1960s. But I feel like the testimony is getting a little bit bogged down in whether or not these guidelines could be effective and whether or not they could be the subject of a lawsuit. And I think I'll change what I was going to say to speak a little bit about my personal experience with guidelines and policies like this. I used to do a lot of contract work in my previous position when I was in Montana. And a lot of the time when I was asked to do policy work, I was asked to write model policies and guidelines for entities because there was no state law that provided those guidelines. So, for example, I was asked to write a model bullying policy and model bullying procedure for the Office of Public Instruction because Montana, unfortunately, is the last state in the country to not have an anti-bullying law. So there were no guidelines in state law. There was no state law that addressed bullying. So those guidelines that came from the department were simply posted on the website as a tool for schools and other entities to use if they wanted to address bullying but didn't know how. And I think that's what this bill does. So we know that a problem exists. I'm sure a lot of businesses know that the problem exists. And the guidelines will provide that. They will provide guidance for businesses and entities who want to combat gender pay equality but don't know how to do it. It's not a mandate, it's not state law, it's some guidance and some procedure and some policy that people can use if they want to start combating the gender pay gap on their own, until better statutes and better laws are actually passed, not just at the federal but at the state level. So I think this is a good first step. I think it's something that people can do by choice, and I think that a lot of good can come of it. And it's not coming, just representatives isn't giving you the guidelines to use. That's what the study is for, that's to figure out what guidelines are necessary and what would be helpful for businesses and other entities in Missouri. I think it's a great bill. I don't think there's any reason to be scared of it, as becoming a mandate or to be scared of lawsuits. I think it's just something that people can use, and I think it's a necessary thing for Missouri right now because there aren't really strong pay inequality laws on the books yet. That's all. I'll sit for questions if you have any. I'm happy to read the quote if you want that I was going to read earlier.
Thank you very much. Appreciate your testimony. Are there others here in opposition? I'm sorry. Not appearing. Mr. Bill Gamble.
Mr. Chairman, members of the committee, I'll be very brief. Bill Gamble, representing the city of Kansas City. And Mayor James, this is a first. I've never testified on behalf of one of Representative Weber's bills before. So if you have a picture, it'd be great. Mayor James has made it a priority of his administration to establish equal pay and gender equality in his hiring practices, and made significant headway, but it's always a challenge to evaluate and make sure that you have fairness and within your system. So it's a top priority of his, and we'd just like to go on record in support of the bill. Thank you very much.
Thank you, sir. Representative Gosum.
I don't think I've ever asked you a question when you were representing one of Representative Weber's bills. No, just a quick question.
Sure.
And that's interesting. So the city, the mayor, the city of Kansas City is kind of taken on a project like this?
Yes. Well, I mean, we're a taxpayer. I mean, it's a taxpayer's entity. So I think it's in the best interest of the city to make sure that you make a practice of reflecting fair hiring practices and fair salary practices.
Have they developed their own model, or is there something? I know, like, when you start a city, there's like model language for your city statutes and stuff. Is there something like that he's going off of?
I don't know, but I certainly could ask and find out.
Because that's what you're looking at here with this bill, right? To generate something that a city could take on,
It could. It's not limited to that, but it could.
And I just was wondering if there's something
Sure,
out there
I will
that cities use. Because like I say, if you're looking to rewrite all your statute in the city, there's model statute out there, there's websites.
Or ordinances, yes.
Yeah, ordinances, I mean, yeah.
Yeah, I know we have a discrimination ordinance on books, and that may include that, but certainly I'll ask the question of our Cecilia Abbott, who is now our acting
Just curious about what they're using
city
as
attorney.
guideline on that.
Sure,
Thank you.
I will do.
Thank you, sir.
You even made me sit down next to Mr. Clerk.
Are there others here to testify in support of this bill? Let me see a show of hands, please. Okay. Didn't have Richard Craig yet? I got you.
Good afternoon, Mr. Chair, honorable members of the committee. For the record, my name is Richard Craighead. I'm here with the United Steelworkers District 11 in support of this bill. And I've attached to my testimony, there's an Institute for Women's Policy Research in Washington, D.C. If anybody wants any more information and facts on this problem. I'm not sure why we're dealing with this in today's time. In organized labor, we don't have those issues. That's one thing you can say about organized labor. If Elaine and I are working on the same job, we're going to get the same pay. And I think that's fair, and I think it's just. So, with that, I'll take any questions if I can answer them.
Thank you, sir. Others testifying in favor?
Honorable Chairman, members of the committee, my name is Bruce W. Holt, I'm a registered lobbyist for the International Union of Painters and Allied Trades. We just want to go on record in full support of this, as we believe equal days work for equal days.
Thank you, sir. Others?
Good afternoon, committee, chair. My name is Shirley Breeze. I'm state chair of the Missouri Women's Network. We're very supportive of this bill and have been supportive of pay equity for years and years and years. Many of the things that I wanted to talk about have already been addressed, but I want to point out just a couple others. When women are not paid equally starting out in their careers, that builds until they retire. They're still not getting what they should be getting, because your retirement obviously is generally based on what you've earned. So it really doesn't just establish inequity during your work life. Your whole life is then unequal. And another point I want to make is, someone mentioned Lilly Ledbetter, and those of you who know the case know well about her problems with Goodyear. But it was established that she was doing exactly the same work as the gentleman who was paid a lot more than she was. It was absolutely equal. No difference in education, training, experience, or whatever. So that is one example of not being transparent, which that company wasn't, and her finding out, years and years and years later, until she couldn't really benefit from any increase in salary. Thank you.
Thank you very much. Others to testify? Remind everyone to please complete witness forms if you're testifying.
Thank you for this opportunity. My name's Jane Krigler, and I'm here from both AAUW and the Missouri Women's Leadership Coalition. The coalition works to get women outside of Kansas City and St. Louis, elected to all levels of office. Very appreciative of this effort to look at this. I work in healthcare, even at my age. I still have a job. And best practice guidelines are well accepted. That's what a thoracic surgeon or a person in the emergency room looks to see what the standard is. It doesn't dictate or mandate anything, but it gives you something to work from. I have brought and will leave behind this newest edition of the Simple Truth that AAUW puts out. And they adjust for everything. As the representative said, time off to have babies, to raise a family. And even then, there is a major gap in nearly every line of work. Women face a pay gap. Among the occupations for which the Bureau of Labor Statistics collects data that allow for valid comparison, women's earnings are higher than men's in only a handful. And they do go by industry. They also show in their, and they actually show better for Missouri than the Women's Foundation showed. We're making some progress. In fact, in the last 2 years, we've come up 3 bumps. We've come up 3 percentage points. But they also show that it's going to take another 124 years to, if we go at the rate we're going now, to have women's pay equal to men's. Now that would be 2139, and I'll be 200 years old then, so I doubt if I'll be around to see that. But there's a lot we can do, and I think this is one step, and because it doesn't mandate anything that shows best practices, it's hard to see what the problem is. But I wanted to also leave, now we were working on the Equal Rights Amendment, and I'd like to leave just this was last year, the brochure or the flyer that we had, because it gives some of the facts for women in Missouri, in addition to what the Women's Foundation has found. Thank you very much. I appreciate the opportunity.
Thank you, ma'am. Are there others here to testify in favor of this bill?
Good afternoon. My name is Ben Burkemper with the Attorney General's Office, and the Attorney General wants to go on record in strong support of this bill.
Thank you very much. Others?
Representative Fraker's gone. I won't get a picture of me. Autophagian, speak on behalf of Missouri NEA. Our platform speaks to proactive attempts by the legislature to really address concerns about pay inequity. We think this is a very smart approach, putting forth an expectation that the department would do best practice guidelines. Reminds us a lot of times when you all will identify an issue and suggest to school boards that there should be a policy, or maybe that the department would put together a model policy. So it really kind of helps raise the awareness and raise the performance across the state in a way that's more proactive, but without a lot of regulation. We think it's a smart approach. We urge the community to move forward. Be happy to answer any questions.
Thank you very much.
Thank you, Mr. Chairman.
Are there others here in favor of the legislation?
Good afternoon. I'm Nimrod Chappell, and it's a pleasure to be here with you. I appreciate you allowing this bill to be heard for a number of reasons, and think that I might be in a unique position to speak to it. As a former director for the Department of Labor and Industrial Relations, this type of work is exactly what that department was organized to do. It protects employees and employers without unnecessarily promoting litigation. Now, some would argue that that litigation is necessary to change the business practices. I don't think that it necessarily is. You should allow this legislation to go forward. Now, additionally, I'm also the president of the Jefferson City NAACP. I'm here on behalf of my constituents asking you to please allow some best practices to go forward, so that if there are good-meaning people here in the state of Missouri that don't intend to commit the moral sin of discrimination, the state of Missouri can be of service to them. I'll take any questions.
Thank you for your testimony, sir.
Thank you.
Are there others here to testify for the bill?
Good morning. My name is Pam Rich, and I'm speaking today on behalf of Empower Missouri, and I have a statement from Jeanette Mott Oxford. Empower Missouri, formerly Missouri Association for Social Welfare, is dedicated to ensuring social justice for all Missourians. It's founded in 1901, and our strictly nonpartisan organization educates and empowers Missourians on issues including hunger, housing, education, health, and economic opportunity. One of probably our guiding principle is basic fairness in all aspects of life. I will pass out this statement. As said before, presently women in Missouri earn 71 cents of what men earn. We believe discrimination based on gender is still present in our society, and it must be remedied. As you know, much financial hardship, both at the time and then later in life, is created by this disparity. And I know I've been in this fight since the 70s and 80s when women are making 59 cents. So one could say, well, we've gone a little ways, but it's been a long, hard pull for 40 years. Thank you.
Thank you very much. Are there others to testify for the bill? Not appearing. Are there those who would like to testify for information purposes? Not appearing. This concludes the hearing on House Bill 44. Representative, thank you very much. We will now open the hearing on House Bill 928. Representative Corlew, go ahead when you're ready.
Thank you, Mr. Chair, members of the committee. My name is Kevin Corlew, representative from District 14 in Kansas City. Today I present to you HB 928, which deals with arbitration agreements between employers and at-will employees. The bill provides that in arbitration agreements between an employer and an at-will employee, the arbitrator must make all initial decisions as to arbitrability, including deciding whether the parties have agreed to arbitrate, whether the arbitration agreement is enforceable, and whether specific claims are arbitrable. The bill establishes certain criteria for when the arbitrator must determine that the arbitration agreement is valid. On motion by a party showing an arbitration agreement between an employer and an at-will employee that does not expressly delegate the issues of arbitrability to a court, then the court must stay any action before the court and order the parties to proceed in arbitration. Arbitration, as you know, is an alternative dispute resolution mechanism. It is meant to be an efficient, timely, and cost-effective for all parties. It is also judicially efficient in that it frees up dockets that otherwise could be filled with more litigation. The U.S. Supreme Court and state courts throughout the nation, including Missouri's, have consistently upheld arbitration agreements as a reasonable and acceptable mechanism for alternative dispute resolution. Courts favor settlements and resolutions reached in ADR or alternative dispute resolution. Despite this stated support for arbitration, it is becoming easier for parties in Missouri who have agreed to arbitration to take the dispute to court, despite having a contract that both parties have agreed to resolve the disputes in arbitration. I will let some of the supporting witnesses today to tell you about how arbitration agreements are used in the employment context and also why this bill is necessary in Missouri. But briefly, the Chapter 435 of the Missouri statute sets forth the Uniform Arbitration Act that spells out the procedures for and the enforcement of arbitration agreements. These provisions state that arbitration agreements are enforceable in Missouri. It is a valid contract that people enter into. A party may challenge the validity or enforceability of an arbitration agreement, and that would not change under this bill. It would just change the form in which to challenge the enforceability or the validity, from taking it to the court versus asking the arbitrator to decide those issues. Parties in an arbitration have similar rights as they do in court, such as they have a right to an attorney, they have a right to present evidence, they have a right to cross-examine witnesses, they have a right to subpoena witnesses, and therefore it provides a valid dispute resolution mechanism, and it's before a neutral arbitrator. So it's not meant to favor one side or the other, but these are neutral arbitrators that are certified and well-versed and particularly specialized in certain areas of arbitration. HB 928 just changes just one aspect of the Arbitration Act, and that is it answers the question, who decides arbitrability? That is, the initial questions, like whether the arbitration is valid, enforceable, and has it been entered into a correct manner. In 2010, in a case called Rent-A-Center West Incorporated v. Jackson, the U.S. Supreme Court again upheld arbitration agreements in the employment context. The court decided that an arbitrator indeed has the authority to decide challenges to an arbitration agreement, so long as the parties have agreed to it. And this bill before you is intended to set forth a presumption that unless the parties expressly agree that a court should decide arbitrability issues, the arbitrator must decide initial issues such as validity and enforceability. Thus, the bill maintains a balance. It still allows parties to contract and honors those contracts if the parties indeed want the court to decide the arbitrability issues. But unless otherwise stated, under this bill, these issues would be for the arbitrator. That is, the bill would achieve the objective of honoring the parties' contracting objectives. We have a variety of groups, I think, that will testify today in support of it, and I'll let them, I'll be open to any questions that you may have, and then let them also expressed their support as well. And I will mention that the one group that was unable to be here due to timing constraints, it was Kansas City Power and Light, and they asked me to extend their support as well as those that you'll hear from today. With that, Mr. Chair, I'll be happy to answer any questions for the committee.
Other questions of the committee? Representative Walker.
Inquire, Mr. Chairman. Thank you, Representative. I think you probably answered most of the questions that I have, but I just want to maybe go over them again. Is an arbitration enforceable?
Yes, it is. It's a valid contract, and in fact, under the act to which this makes an amendment, these are enforceable. In fact, a party can go to court to confirm the award and get a judgment, actual judgment, which is the same as any other judgment or decree.
Okay, and under your House Bill 928, may a party challenge the validity or enforceability of an arbitration agreement?
Yes, they still may challenge that. What this does is, in other words, I could say that, yes, we've got an arbitration agreement, but it's not enforceable for these reasons, or it's not valid for these reasons. And you can still challenge that. The difference in this bill, though, is that you do that within the context of the arbitration. So you ask the arbitrator to deal with those issues. So unless, again, as provided in the bill, you've expressly agreed that the court should decide those issues.
A couple more questions. Does a party to an arbitration have the right to be represented by an attorney at the arbitration?
Yes, they do, and this bill would not change that. They could still be represented by an attorney.
Okay. And I think that's good. I think you've got a good bill here, and I support your bill, and thank you for bringing it forward.
Thank you, Representative.
Representative Burns.
Thank you, Mr. Chairman. Permission to inquire?
Go ahead.
Thank you, Representative, for bringing this. Can I ask you, what is the motivation why you brought this?
Despite the fact that arbitration agreements are upheld throughout the nation, in Missouri, in the employment context, recent decisions have started to cut away about the enforceability of that, allowing issues to go to court that normally would be decided by the arbitrator. What happens is if I'm able to take the arbitration to the court by expressing an enforceable or a validity question or enforceability question, then for all intents and purposes, the case is decided in court. And then what happens is the reasons that I entered into the arbitration agreement in the first place, such as cost effectiveness, timeliness, cost efficiency, those reasons have gone away, and we are involved in costly and prolonged litigation.
Also, years ago,